And welcome. Hello. Yeah, you got Employment Law Show. You've just seen it right there in the banner. That's what we're doing for the next 30 minutes. So good to have you along for the ride. John Scholes here, Lior Samfiru right there from Samfiru Tumarkin LLP. You want to reach out, stlawyers.ca. You can phone Lior and his team. They're always ready to have that simple chat with you to discuss any issues you have or something you hear and want to learn more from this particular show or our radio shows or the YouTube live chats they do. 1-855-821-5900, help@employmentlawyer.ca, and the website we always direct you to every week is pocketemploymentlawyer.ca. So many questions can actually be answered through pocketemploymentlawyer.ca before that phone call even, and access to that severance calculator, which millions, and I mean millions of Canadians have used and had their eyes opened up as to the correct amount of severance you should be receiving from soon-to-be former employer. But always go there first, pocketemploymentlawyer.ca. Main topic in just a bit, a little later on the half hour, 5 fast facts about without cause termination. Lior, that's coming up, but we always get warmed up and stretch a little bit, as you say, with the other week there was a case of the day, pal. What's going on?
Hey, John, it's great always to be here, and the reason I say it's great because I consider it to be a real privilege to be able to sit here and to talk about this very important topic. I have people email me, call me, stop me on the street and say, hey, I learned something. I appreciate that information. It helped me in a difficult situation, or at least I know what to do now if I'm going to face a workplace issue. And that is the point. That's why I'm here, and I'm going to continue to be here because those questions don't go away. Good economy, bad economy, recession, inflation, you name it, those issues are there. They're always going to be there. So if you have a workplace problem, chances are the law has a solution, and chances are I've seen it already, I've dealt with it already, and I can help guide you through that issue. On the show, we tell you what you need to know when you're dealing with a workplace problem, because it's not always going to be sunshine and rainbows. There's going to be times when something bad happens in the workplace, or it raises questions. Maybe you're given an ultimatum and the job that seems so great all of a sudden is maybe not so great. What to do, especially if you lost that job and you're worried about finding new employment. What are my rights? What am I owed? We talk about those topics, and of course, beyond just the 30 minutes of the show, if you want to talk to me, not going anywhere, you can call, you can email. Throughout the show, we'll give you that contact information. Take advantage of that, okay? Because we can only fit so much in 30 minutes here. There's probably a lot more that you want to discuss, so reach out then. But case of the day, let me tell you about a situation that came across my desk very recently. I spoke with a gentleman who has elderly parents that live overseas. He's an only child, and he lives in Ontario. His parents live overseas, and unfortunately, his father recently took ill. So he spoke to his employer, and he said, I need to go out there and help my mother care for my father for a while he's getting some treatment, while he's in the hospital. So I'm going to be gone likely for the next 3 to 4 weeks. Please approve that. Company said, no, this is our busy time. We can't do that. Hopefully we can do that a bit later in the year if you need to go, but we cannot approve you to go for that long. And by the way, if you do, we'll consider that to be a resignation. Certainly we can't tell you that your job is going to be here waiting for you. He went back and forth, and ultimately there was no solution. Thankfully, he called me, and he did the right thing by speaking to me. So here's how this breaks down from a legal standpoint. Under our human rights laws, there's an obligation to accommodate based on family status. What that means is if you're in a parent and child relationship, whether you're dealing with your own child or with your parent, your employer has to accommodate any care needs that come up. In this situation, under that legislation, under human rights and the duty to accommodate, the company had to give him that time off, had to allow him to be off work to care for his father. That was the only way he can care for his father, through that help, through that support of his employer. So they had an obligation to do that. But this story, thankfully, has a good ending. I got involved. I sent the company a letter, and they changed their tune very, very quickly. Once they knew they were in the wrong, they approved the time off, and this gentleman is out now, hopefully caring for his father. But I wanted to remind everyone there that that duty to accommodate based on family status, it does come up, and it's an important one. You may have a child that requires supervision or requires care, whether it's medical or other care, and there's no other way that you can provide that care unless you have some help and support from your employer. In that situation, your employer has to accommodate. Even if it's difficult, even if it's going to upset other employees, they have to do it. Just like they have to accommodate anything else, they have to accommodate this family status. If they don't, give me a call. I can help you hopefully solve it like I did in this situation.
I think this one, Lior, sounds reasonable. It's 4 weeks. That's a reasonable amount of time. You got to go overseas. You got to take care of your pops and come back to regular life. Is there I don't know, but the best word is legal limit to how much time you could extend? What if it wasn't 4 weeks? What if it was 6 months you had to be over there?
So the duty to accommodate, this obligation to accommodate, it's to the point of undue hardship. What that means is the employer has to accommodate even if it's difficult. It's understood and expected that accommodation is not always going to be easy. Now, of course, there's a point where it becomes so hard, so difficult, so costly that the company doesn't have to go that far. So every situation is going to be different. But unless the company can show that that accommodation is just going to be so over the top, unless they can show that, they still have to do it. So no, there's no time limit as to how long it can be off. Maybe it's a month, maybe it's 6 months. And frankly, the bigger the company, the probably more they can absorb by way of accommodation. It's going to be very difficult to accommodate you if you're working with a company that only has one other employee. But if the company has 1,000 employees, probably easier to accommodate. It's very difficult for the company to say, we don't have to accommodate.
If we take this particular scenario, Lior, make it maybe more local, so this person's father is local here in the GTA. Same scenario, though, got to be off for 4 weeks till they get sick, till they get better. But after they come back, if their dad needs some help moving around, some help doing other things, and it's an ongoing situation where maybe I've got to leave work an hour early, come in an hour late, something like that. Do they have to accommodate ongoing?
So remember, when it comes to caring for your family member, child, parent, etc., you have to try to see if there's other arrangements that you can make. Now, if you've tried and there's no other way, either because you cannot do it financially or there's no one available to help you, then the company's obligation factors in, and that's when they have to accommodate. But it's not necessarily the situation where you say, well, it will just help me out, employee, if you did this for me. There could be other options, but I'd prefer you give me flexibility at work. If that's the only way you can provide care, then yes, that duty becomes an obligation.
EmploymentLawyer.ca, that's a quick place to go if you want to find a radio show pretty much in Ontario and across the country, where Lior and I have been doing our show for many, many years. We get a lot of great phone calls on the show. We like to play them back and talk about them for experience and education on this half-hour show. We'll get to our first radio show phone call right now.
I am 56 years old. I recently moved and took a job with a small company in sales, and my base salary was $55,000 plus commission paid on projects or jobs, and they severed me because the business is slow, and they've offered me 2 weeks.
Okay.
So there's two things I want to talk about here. Number one is the idea that he's a short service employee. So he's been there for about a year, so it may be easy to think, well, maybe he gets a week, 2 weeks. They offered him 2 weeks, so he's doing okay. Wrong. He has significant entitlements even as a short service employee. Remember what I've said before on the show. The short service employees would say 3 years seniority or less, have disproportionately greater severance rights than employees with long service. So you may be owed several months' pay even if you work for a short period of time. Now, there's another aspect to this. If he was recruited from another company, he's only worked there for a year, but he was recruited from another company, he may be owed enhanced severance that recognizes his time with the previous company. So bottom line is, either way, any way you look at it, this person is entitled to much more than the 2 weeks that he was offered. So let's find out how much he's owed. We're going to go, of course, and use our severance calculator tool like we do every week. You can find that at pocketemploymentlawyer.ca. Let's plug this person's information in and let's see what we get for severance. So he's in a sales role. He's been there for about a year, 56 years of age. Company says you get 2 weeks. You've only been here for a year. Well, you see on your screen he's owed anywhere from 3 to 6 months severance. And by the way, that number can be much higher than that if he was recruited from another job. So that's why it's so important to go to pocketemploymentlawyer.ca, use the severance calculator. It could be the difference between accepting the 2 weeks that you were offered and the 6 months that you're owed.
Before we just get into that second phone call momentarily, Lior, you keep mentioning that disproportionate amount for short service. Why is that? Why can't it be?
Well, the law, when it comes to severance, looks at how long should it take you to find another job, right? So just because you work for a company for a short period of time doesn't mean you'll find a job in a week. So in fact, it could be even harder to find another job because you'll have to explain why you only lasted 6, 8, 12 months in the previous job. That's why short service employees still have significant entitlements. It's recognizing the fact that replacing your job is not going to be easy.
Told you, you can always get answers on this show. Let's get to phone call number 2 right now.
I'm a software guy at an engineering firm. I feel like the writing is on the wall as the company's doing tightening, but the criteria that they're kind of evaluating my expected daily deliverables is very vague. How do I kind of handle some of those situations? Is a termination from failing to meet a performance review, is that something that gets EI?
So there's a couple of things that I want to talk about here. Number one is if the company is setting unrealistic expectations, unrealistic deliverables or goals, and they're trying to hold you to it, if you know they're unrealistic, if you know that's not attainable, I want you to say so. And I want you to say so in writing. Send an email explaining why those goals are not attainable, why it's not possible. Because if you're given these goals, you don't say anything and you don't meet them, it's almost going to look like it's your fault. We set these goals. You never said you had a problem with them, and now you didn't meet them. So right off the bat, I want you to say so. Now, you don't need the company to change the goals. It'd be great if they did, but it's important that you be on record saying in writing that what the company is expecting is unreasonable. Now, despite all this, even if you're let go because you didn't meet goals or because you didn't hit all the deliverables, you're still going to be owed EI, you're still going to be owed severance. The only way you can be deprived of those things is if you've done such a bad job that it's almost deliberate, that you've almost done a bad job on purpose. Very, very difficult to prove, very difficult to deprive you of severance and EI, but always respond to any goals that are set if you don't agree with them.
All right, we're going to keep rolling here. We got another phone call on the other side of the break and 5 fast facts about without cause termination. That is coming up on the other side as well, so stick with us as we continue with lots more of the Employment Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show is where you're parked, and we'd like to have you here every half hour on this particular time to learn so much more about your employment rights, workplace rights, and always reach out to Lior as well, 1-855-821-5900 and help at employmentlawyer.ca. And again, from our radio show, for this show, third phone call is coming up right now.
I've been on long duration leave for quite some time, but things are looking a bit better here, and my doctor, I believe, is going to give me permission to go back, but on modified duties. My question in regard to that is, if I go back on modified duties, I was fairly highly paid supervisor, would they have to pay me my full wages, or can they pay me less wages because I'm on modified duty?
That's a great question. That's a really good question.
That is a good question, and it's certainly something that hasn't been asked enough, and it should be asked. So let's be clear on this. Yes, if you're going to be now doing a different job because of these modified duties, your employer can pay you a different salary. Now, it can't be arbitrary. It can't be, well, because you need to work from home once a week, we're going to pay you less, because you're still doing the same job. But let's say you were in a position that paid a certain amount of money. Now, because of the duties that you can do, it's going to be a different position. Well, your employer can pay you what that new position pays. They don't have to necessarily maintain your old pay. But again, it's not as simple as the company saying, you need accommodation, that means less money. That has to be a reason. There has to be a basis. They essentially have to show that they would pay that amount to someone else doing that new role. So in many cases, if the company reduces your pay, not legal, but they have the ability to pay you less if that's what the new role requires.
And our main topic, as mentioned, 5 fast facts about without cause termination. Number 1, right here, Lior, your employer can terminate your employment for any reason, pretty much at any time.
That is very true, and that is something that many people are surprised by. Hey, if I did a good job and I've been working for the company for a while, why should they just let me go? That's not right. And you know what? I agree with you from a business standpoint, from an ethical standpoint, but the law says something different. The law says that your employer can let you go at any time, pretty much. Will give you some exceptions, so long as severance is paid. That's why you hear us talk so often about severance on the show. It's because that's what the law does and that's what the law understands. When it comes to losing your job, for the most part, we're not going to factor in the reason. With some exceptions, we're going to look at severance. And where a wrongful dismissal happens is if you're let go and not paid your full severance.
Without cause, fast fact termination. Number 2 is terminations cannot be due to discriminatory reasons. We're talking about gender, religion, age, stuff like that.
Exactly. So we talked about the fact you can be let go for any reason. Well, the exception to that is you cannot be let go for discriminatory reasons. You cannot be let go because you're 65 or another age, because you're of your gender, because of your sexual orientation. All those things are illegal. Disability as well. That's a human rights violation. You cannot be let go in violation of your human rights. Regardless of severance, that is illegal. And by the way, even if, let's say, your age, even if the reason you were let go is not just your age, there were several reasons, but even if age was one of those reasons, it's already illegal, cannot happen. So no, you cannot be let go for discriminatory reasons.
Number 3, Lior, is this: a termination without cause applies even if you made a mistake, didn't make your goals, or even failed a performance review.
Exactly. So there's 2 types of termination. Termination without cause, meaning you get severance, and a termination for cause, meaning you don't get severance. The only time you can be let go for cause if you did something terrible, if you did something so bad that it's now not possible to employ you anymore. Maybe you've made a mistake, maybe your performance was lacking. That still doesn't mean you can be let go for cause. The law is still going to consider that to be a without cause termination. And why is that important? Of course, you know, because severance has to be paid. So yes, even an employee that did something wrong, very, very likely is owed their full severance up to 24 months' pay.
Without cause termination, fast fact. Number 4, we're getting to the end of the list here, pal, says you are owed full severance pay when you were let go without cause. There you go.
Exactly.
Yep.
So that's really the key here, full severance. Not your minimum severance, not a week per year of service. Nonsense. Forget about that. Your full severance could be 24 months pay. Frankly, in some situations, it could be higher than 24 months pay. If you want to know what you're owed in a without cause termination, which is the most common type of termination, use the severance calculator. Go to pocketemploymentlawyer.ca. Answer a few questions. It's going to take you seconds. Find out what you're owed, or call me just as easily. I can tell you, but you have significant severance entitlements.
Okay, last one, number 5, right here, Lior. You have up to 2 years after being fired without cause to claim severance pay. Most people don't realize that.
Exactly. And you know, too often, by the way, I get people that heard the show or seen us on TV or heard it on radio wanting to know, can I help them from something that happened 5 years ago? I can't help you with that, but you do have up to 2 years from losing your job to pursue your severance. That also means that that deadline, that severance deadline, is irrelevant. They may have given you 5 days to sign that back. Who cares? Your legal rights don't expire for 2 years. Nothing happens on that 5-day ultimatum. So take your time, make sure you get the proper advice, because once you sign off on that severance offer, it's too late.
We had a phone call once, I think, if someone from the early 70s called in and said, and you were like, well, if I was born, possibly I could have helped
Maybe.
you. A little over the 2-year mark. Right?
Yeah, slightly. And I do get that. You know, people realize, oh my gosh, I just went to the calculator and I realized that I was owed another $55,000, but it was 4 years ago. Can you help me? No, I cannot. That's why you don't sit on your rights, but you also don't sign off on that severance letter by that deadline, because it doesn't matter.
TerminationQuestions.com. Great website. You can ask your questions there. They may appear on this show. That is where we're going after a short break, so stick around. We got more of the Employment Law Show on the way. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thank you so much for hanging through the break. Employment Law Show weekly here. And you can reach out anytime if something piques your interest that we talk about, or you want to ask a question yourself. It may appear through email or the website terminationquestions.com. You can use that, or the phone call, 1-855-821-5900, anytime to Lior and his team, and help at employmentlawyer.ca. But I mentioned, Lior, terminationquestions.com. Love the website. Really easy to use. Desktop, phone, laptop, whatever you got. Lior, I worked for a company as a sales rep for 15 years. I'm 45 years old. I was classified as a contractor. Last month, I was let go when they changed their whole sales structure. I was told that since I'm not an employee, I'm not owed any severance. Is this accurate?
So, John, do you think it's possible for someone to work for 15 years for a company and still not be an employee of that company?
Right.
It's not possible. Okay, so you had me at 15 years, as they say. No, the reality is that this person is an employee. They've been misclassified. By the way, this happens often. I promise you right now, you may be sitting at home thinking that you're a contractor. No, you're probably not. You've probably been misclassified. The fact that the company that you work for says you're a contractor, maybe you signed a piece of paper that says that, maybe you've been paying your taxes to CRA as a contractor. None of that actually makes you a contractor. If you look like an employee and you act like an employee, you are an employee. That means if you have a regular job, if you go to work, you do the job that the company tells you to do, you come home, go back the next day to do the same thing, you're doing it regularly, well, the company is your employer. A contractor is someone that's in business for themselves. They run a business. They have several clients. They decide on the hours. They decide on how much they charge. That is what a contractor is. If you're not that, if you have a regular job, you are an employee. And that's important for several reasons. In the context of this particular question, it's important because if you lose that job, you are owed your severance, as any employee would. So the company can't avoid paying you severance by calling you something that you're not. If that was the case, every employer would do that. We would have no employees. We'd just call people contractors, and the company wouldn't have to pay anything. Nonsense. It doesn't work that way. So we know this person is owed severance. Let's go back to our severance calculator tool and see how much severance he's owed. We're going to find out, of course, at pocketemploymentlawyer.ca. So this gentleman is in a sales role, been there for 15 years, 45 years of age. Company says, nah, you're a contractor, trust us, no severance. Well, you see he's owed as much as 16 months, 16 months of severance. That's a significant amount of severance. I don't care if you're making minimum wage or a lot of money, 16 months is going to add up very, very quickly. That's why it's so important to understand if you've been misclassified and to call me if you lost your job.
What if, Lior, and there's probably at least one person right now shouting at their TV going, Lior, that can't be right, because, you know, my employer, who just happens to be maybe a buddy of mine, we agreed I'm a contractor. Okay, you're a contractor. We shook on it. Everything's smooth as smooth. Why does it make a difference?
Well, it does, because it doesn't matter what you decide, what I decide, what the company you work for decide. The law comes in and decides that for us. And again, going back to my example before, if all it took is a handshake, why do we have employees? Why not everyone be a contractor? You know, the kids working minimum wage jobs at fast food jobs, people working at manufacturing facilities, executives, they can all be contractors. What a great world, supposedly. Of course, that doesn't work that way. Again, if the law would come in and say if you act like an employee, you are an employee. We don't care about that handshake. We don't care what you sign. We don't even care if you've incorporated. It's always about substance over form.
We will go now to a question from the live stream. Lior and his other lawyers host on a weekly basis, Facebook and YouTube. You can join in at stlawyers.ca. If my employer moves me to a new department, can they change my hours? I've been working the same schedule for 10 years and nothing in my employment contract mentions working weekends or evenings.
Absolutely not. So reducing your hours and certainly making you work weekends and evenings when you haven't done that before, that's a significant change to the terms of employment. If you are kind of a regular 9-to-5 person, but now you're going to have to work weekends and evenings, massive change, probably one of the biggest changes that an employer can make. And because it's such a big change, it's not allowed. It goes beyond what a company can do. So if you're facing a significant change, your shifts have changed, your hours have changed, you've been demoted, etc., you may be able to consider that a constructive dismissal. Constructive dismissal happens when you're faced with a change, a big, significant change to the terms of your employment. That means you can consider your employment as being terminated and get severance. Remember, the company is not letting you go. They're not saying you're gone. We're just going to change your job. But you, the employee, can decide to look at it and consider it to be a termination and get your full severance. Of course, you have to act quickly on it. If you don't, if you continue working for a while, you're going to be considered to have accepted what the company did. But if you're facing those types of changes, call me immediately.
What if you're, you really like the job, you like the people you work with, you want to be a team player, a good soldier, and you think, maybe this won't be too bad. Can I take it for a spin, try it for a bit without committing to it?
Yeah, maybe working weekends, I can get used to that. Maybe
out of the house, maybe?
Yeah, maybe out of the house, or maybe if I work evenings, it frees up my days. Maybe I like that. I don't know. Well, yeah, you can try it, but what I want you to do is I want you to tell your employer that you're not accepting it. You're just going to try it for the next few weeks to see how it goes. If you put that in writing and you try it for a few weeks, you'll be able to do that, but only if you tell your employer. If you don't say anything, you're going to be considered to have accepting it. So yeah, there is the ability to try it out for a while.
And this one change does not give your employer carte blanche to make all kinds of, we change your hours, we're going to change your pay now, your location. No.
Well, the thing is, if you accept it and you continue working and you're the good soldier, and you know what, forget it, I'll just start working weekends and evenings. By agreeing to that change, you've then agreed potentially to other future changes. And then if they want to reduce your hours, change your hours again, you won't be able to do anything about it because you let it happen the first time.
Again, guys, reach out anytime before you say yes or no to Lior at the phone number or the email address as well. It is now that time of the show. We're getting near the end, but we're going to squeeze in time for the Employment Law Show Rapid Fire Questions. Here we go, rapid fire. I ask, he answers. Very simple. Number one, can you be fired for going on long-term disability benefits? Wow.
Absolutely not. Seen it happen, illegal. You can be off as long as you need to, so long as you have a doctor's note. There's no time limit on that, and if your employer lets you go because of that, human rights violation, easy.
What if they ask you what's wrong with you?
Again, offside.
Right.
Can't do that. All they have the right to know is, can you work, can you not work, and what accommodation do you need? Rapid
fire number two, are employers obligated to pay employees while they're on a medical leave?
No. The answer is no. Your employer doesn't have to pay you while you're on leave. They also don't necessarily have to continue your benefits. You may have payment through a disability insurer. You may have payment through government benefit, either CPP or EI. But your employer does not have to pay you if you're not working.
Rapid fire question number three, can your employer withhold tips and commission payments?
No, and even if it's to punish you, you didn't do a good job, so we're going to withhold pay or commissions or tips. Can't do that. If you earn something, money that's earned has to be paid, and there's almost never an option to not pay you that. That's one of the biggest no-nos in employment law. If you earned it, you have to get it paid.
Next one, let's go. Innocent errors at work do not justify termination for cause.
Correct, absolutely right. It's very difficult to terminate for cause, and doing something wrong is just not enough. It'd have to be pretty bad to be able to be let go for cause and be deprived of your severance, and that's almost never the case.
Most people don't know this one. Are all employees automatically on a 3-month probation when they start that new job?
Probation is not automatic. Even if you just started a new job, you're only on probation if you sign an employment agreement that says you're on probation.
One more, we'll get it in. Are employees owed severance if pressured to resign?
Absolutely. If you can prove that you've been pressured and that's why you resigned, that's a termination and you're owed severance.
It's enough cardio for one day. Rapid Fire is complete. So is a complete 30-minute show. Appreciate for all your input and watching this half hour. Join us anytime next time and reach out to Lior, 1-855-821-5900. help@employmentlawyer.ca and the website, pocketemploymentlawyer.ca as well. We'll catch you next time. Thank you so much right here on the Employment Law Show.